So the Amadiba Crisis Committee has launched court action to try to stop the SA National Roads Agency from imposing a road on communities in the Eastern Cape Wild Coast. The committee wants that road moved about 10 kilometers from the coast. The 410-kilometer long stretch of road runs from East London to Port Edward and will cut through communal land. SANRAL says the road will only impact a limited area of grazing land, but communities there say that this decision to approve the use of land must come from a traditional court. Spoor Attorneys is acting on behalf of the community, and Johan Lorenzen is an associate at that firm itself. He joins us now via our telephone line. Johan, it's great to have you on the program. Thanks very much indeed for making time for the AM report. This case should not be confused with the case against Shell, even though they both involve the Wild Coast. So perhaps let's begin by breaking down the circumstances behind this latest court action, specifically by Spoor Attorneys.
Thanks. Can you hear me? I'm sorry.
Loud and clear. Please go ahead. Sorry,
we're having some network problems here, but thanks so much for the question, for the opportunity to speak to your viewers. This is a vital case. It's a very important case, and it's launched by the community to challenge SANRAL, not to say that the toll roads cannot go ahead, but to say that when SANRAL builds the toll road, they must engage with the community. They must determine in advance a resettlement protocol that prevents the devastating consequences that the World Bank research, SANRAL's own experts tell us, can cause devastating consequences of poverty and landlessness when a toll road is built without such a plan. Of course, our clients also say that if such a plan is properly prepared, that will consider their demands that the toll road be moved a mere 10 kilometers away so that it doesn't cut their community in half, which is something they believe will be devastating, and so that it won't subsidize the clothing mine, which they oppose. I don't know if that makes sense, and I hope the network is with me.
Okay, no, you're coming across loud and clear, and you're making a lot of sense. This is also one of several cases where we're seeing communities finally take a stand against, in some instances, multinational conglomerates, and that has to do with the matter to do with Shell. But I mean, jurisprudentially, do you get the sense that, this community has a leg to stand on in fighting against this type of development on the basis of just consultation with even some of their traditional structures? Johan, are you still with us?
I am, but sorry, I couldn't hear the question.
Okay. Let me try to repeat it just one more time, for the benefit of our viewers as well. I was just pointing out the fact that this is one of several cases where communities are taking on institutions, sometimes multinational conglomerates. And I was just hoping to gauge from you whether jurisprudentially you get a sense that the community in this particular case has a leg to stand on.
We certainly think so. Of course, it's our client's case, and we stand by it. I don't want to overstate anything, but we think the case is a lock. The SANRAL's unlawful conduct, as our clients say in their affidavit, is just so blatantly unlawful that we are confident that a court is going to come to our client's aid. It's just very frustrating that our clients have to go to court in the first place. But no, our courts, we think, are doing an exceptional job developing a jurisprudence that reflects communities' aspirations and needs, that reflects the importance of consultation, not to stop development, but because any development, for it to be meaningful in South Africa, requires consultation and buy-in from the people who are, quote-unquote, developed.
Yeah.
So we believe that the courts are going to be with our clients. But again, it's incredibly disappointing that government is making our clients go to court instead of doing their job.
Yeah. Let me try to sneak in one more question while the line is with us. The court action itself was launched yesterday, but has any development actually started in the community itself? And if so, what are the implications for that?
So on our client's land, the toll road construction has not happened. But that is purely because our clients have been using their bodies to stop it from starting. But the toll road construction has started in other communities, and our clients say in their court papers that they think what has happened in other communities reflects the importance of their legal case. And they say that because in the Jama community, for instance, the community initially supported the toll road. They supported it extensively, and they still support the toll road in concept. But the way that SANRAL has been conducting the process of relocating community members, and the way that SANRAL has not ensured that community actually benefits from the project, led that community to not only shut down operations for 3 months, the contractor for a 1.6 billion rand contract pulled out because of the community dissent. And our clients say in their court papers, this is exactly the risk of disrespecting communities and of SANRAL's unlawful conduct. That if you don't follow the obligations to prepare a resettlement action plan, you will have severe investment consequences because communities will react to the devastating consequences that come with this type of project. Following the law is the minimum that's required for this investment to succeed. So I hope that speaks to your question.
It absolutely does. Johan Lorenzen is an associate with Spoor Attorneys. Johan, once again, thanks very much indeed for your time.